Welcome back to our podcast series on blockchain, tokenization, and crypto assets. I am Sotiris Kolelis, and I'm here again with Dr. Anastasia Mallerou. Welcome back.
Hello, Sotiris. Always a pleasure.
In our previous episode, we discussed the legal and operational framework of tokenization. Today, you suggested we go one step deeper. What is the focus of this episode?
In episode 4, we examined how tokenization works. In today's discussion, I suggest bringing conceptual clarity to the term tokenization and examine what is actually being tokenized. This may sound obvious, but in practice, the market often groups together very different phenomena under the single label of tokenization. We should, however, distinguish between two fundamentally different categories. First, the tokenization of real-world assets, and second, the tokenization of digital assets. We can easily refer to these two categories as off-chain and on-chain asset tokenization, respectively. Although the two may appear technologically similar, the legal implications are markedly different.
So, the message is that not all tokens are created equal?
Precisely. From a technological perspective, they may look similar. They are all entries on a blockchain. However, from a legal and regulatory perspective, the differences are profound. Failing to distinguish between the two can lead to structuring mistakes, misclassification, and regulatory exposure, especially for financial institutions and fintech firms operating in the European market.
Let us build on what we discussed in our previous episode. When people in the market say tokenization, what do they usually have in mind?
In market usage, the term tokenization is often employed as an umbrella label for a wide range of blockchain-based value representations. Building on our previous discussion, the more useful question is not simply whether something is tokenized, but what exactly the token is intended to represent. In its most legally complex form, tokenization refers to structures in which a token represents or tracks rights in an asset that exists outside the ledger. This is the typical case of real-world asset tokenization. By contrast, a significant category of the so-called tokenized assets consists, in fact, of purely digital assets. These do not mirror an off-chain asset. The token itself constitutes the object of value. In these cases, the language of tokenization is used in a broader, most functional sense.
Let us take this one at a time. What exactly do we mean by purely digital assets?
Purely digital assets are those whose existence is entirely dependent on the blockchain. They have no independent legal or physical substrate outside the network. Typical examples include certain utility tokens, governance tokens, many crypto assets issued by protocols, and some NFTs that do not embed off-chain rights. In these cases, the token is not a representation of an external value. It is itself the primary object of value.
And why does that matter legally?
Because the legal analysis is fundamentally different for the two categories. In the case of purely digital assets, the key questions tend to revolve around regulatory questions. For example, does the token qualify as a crypto asset under the EU MiCA regulation? Does it constitute a financial instrument under MiFID II? How do custody and safeguarding obligations apply? What are the market abuse and consumer protection considerations? What are the applicable governance and disclosure obligations? And so on. On the other hand, in real-world asset tokenization, the legal inquiry is primarily around proprietary issues.
So, in the case of purely digital assets, we are less concerned with property law questions?
Yes, you could say so. Property law questions do arise, of course, but in a different way. With purely digital assets, the central issue is typically control over private keys and the legal nature of the crypto asset itself. By contrast, real-world asset tokenization immediately triggers classical private law questions.
Let us turn to that. What is real-world asset tokenization in strict terms?
Real-world asset tokenization refers to arrangements where a token is intended to represent rights in an asset that exists off-chain. Such assets may be, for example, securities, real estate interests, fund units, also commodities, receivables, etc. In these structures, the value of the token depends on a credible legal link between the on-chain token and the off-chain asset.
And this is where things become more legally delicate.
Very much so, because now we must ask a series of difficult questions that do not arise, or arise only marginally, in the purely digital asset context.
For example?
First, what is the legal nature of the right that the token holder actually acquires? Is it a property right, a contractual claim, a security, or merely a contractual arrangement that gives the holder economic exposure without direct rights in the underlying assets? Second, how is the link between the token and the underlying asset legally secured and enforceable? Third, what happens in the event of issuer's insolvency? Fourth, which law governs the proprietary aspects of the arrangements? These and other questions are often underestimated in the initial structuring phase of tokenization projects.
I understand that technologically the token can point to an asset. Why is that not sufficient?
Because technological linkage is not the same as legal enforceability. A blockchain entry can indicate that the token corresponds to an ownership interest in a building. But unless the legal documentation and, where applicable, the property registry recognizes that linkage, the token holder may have no enforceable right on the underlying asset. In legal terms, the crucial issue is whether the token structure is legally effective against third parties.
So, the risk is that the token becomes economically meaningful but legally fragile?
That is an excellent way to put it. Often the technology is sophisticated, but the legal framework remains underdeveloped. For instance, in tokenized real estate projects, if the underlying property remains registered in the name of a special purpose vehicle, unless the structure is very carefully designed, the token holder typically has only a contractual claim against the issuer. This has significant implications for insolvency risk, investor protection, and regulatory classification.
Where does EU regulation, particularly MiCA, sit in this picture?
EU regulation is clearly relevant, but its role depends on the legal characterization of the token in question. MiCA provides a horizontal framework for crypto assets and related services. However, it does not displace the need for a careful qualification exercise. In a number of tokenization structures, particularly those involving real-world assets, the token may instead fall within the scope of existing financial services regulation, such as MiFID II, or remain primarily subject to national private law rules. Accordingly, the lawyer's first task is one of legal classification. In particular, does the token qualify as a financial instrument? Does it fall within the scope of MiCA? Or does it sit outside both regimes while still engaging national law constraints? Only once this mapping exercise has been properly conducted can we identify the applicable regulatory perimeter.
So the takeaway is that tokenization does not magically bypass traditional law?
Precisely. One of the persistent misconceptions in the market is that blockchain somehow disintermediates legal infrastructure. In real-world asset tokenization, the technology overlays existing legal frameworks and must operate in coordination with them. Any weakness in that interaction gives rise to legal risk.
Let us bring this back to market participants. Why should banks, fintechs, or asset managers care about this distinction between on-chain and off-chain asset tokenization?
because the distinction directly affects regulatory strategy, structuring choices, custody models, disclosure obligations, and ultimately liability exposure. If an institution treats a real-world asset token as if it were merely a crypto asset, it may underestimate property law and investor protection risks. Conversely, treating a purely digital asset as a traditional security may impose unnecessary regulatory burdens. In short, correct legal taxonomy is a risk management tool.
Are we seeing supervisory attention on this point?
Increasingly, yes. European supervisors, including ESMA and national competent authorities, are scrutinizing tokenization structures, particularly where questions arise as to legal classification, investor protection, or the potential circumvention of existing regulatory regimes.
Before we close, what would you flag as the most common pitfall in tokenization projects today?
If I had to single out one, it would be the assumption that technological representation equals legal transfer. Many projects invest heavily in smart contracts, token standards, and platform architecture, but comparatively little in the underlying legal design. The result can be a structurally elegant system with, however, fragile legal foundations.
And I assume this is where careful legal structuring becomes indispensable.
Exactly. Tokenization is not merely a technical exercise. It is fundamentally an exercise in legal structuring. The closer the token comes to representing real-world rights, the more demanding the legal analysis must be.
Very clear, Anastasia. Thank you once again for the discussion.
Thank you, Sotiris.
And thanks to our listeners for joining us. Stay tuned for the next episode, where we'll continue exploring other interesting aspects of blockchain, tokenization, and digital assets, building on the concepts we've discussed so far. For more information, visit www.vernitsaslaw.com or reach out to us directly.
This is Vernitsa's Law Podcast, your window to the latest legal developments in Greece. This podcast is intended to provide general information and is not meant to constitute a comprehensive analysis of the matters or to be relied upon as legal advice. It is not meant to create a lawyer-client relationship. Legal and other professional advice should be sought before applying any of the information in this podcast to a specific situation.